Okay, well, thank you everyone for coming. It's so great to have you, and thank you to my Bachelor of Justice Studies students for allowing us to do this today. It's really great to be able to offer the opportunity to bring guests in from across Canada and possibly around the world. My name is Kathleen Mannion, and I am the program head for the BA in Justice Studies. And this is our class in Introduction to International Law and International Organizations. Before I get into introducing our guest speaker, I want to acknowledge the fact that we do sit here at Royal Roads University on the ancestral land of the Kusapsan and Algonquin people, otherwise known as the Songhees and Esquimalt people. And we are in gratitude also to our neighbors of Beecher Bay and Sauk Nations as well. And it's lovely to have you. And I also want to acknowledge the traditional territories which you, the viewers, are watching from. I'm really excited today to be able to introduce guests from the Canadian Red Cross and to welcome them into our home. As stewards of the Geneva Convention, I'm happily invite them to introduce international humanitarian law, in particular, look at the celebration of 70 years of the Geneva Conventions, recognizing some of the earlier iterations of these conventions. Also want to recognize that today is May Day, so happy May Day to people. And again, before I introduce our main guest speaker, I want to express gratitude to Karen Stone from the Canadian Red Cross for helping organize this with me. And with that, I happily introduce Catherine Gribbin, who is on screen with us now. And thank her for sharing her expertise. She's sitting in Ottawa in her office with us today. Catherine is a senior legal advisor in humanitarian law at the Canadian Red Cross, where she has worked since 2006. She was the operation legal coordinator for the ICRC's Nigeria delegation in 2017 and 18. She received her LLB from Dalhousie University and articled in Toronto during criminal defense. She was called to the bar in Ontario and Nova Scotia and is a member of the Law Society of Upper Canada. Welcome, Catherine, and I turn it over to you now.
Okay, wonderful. Thank you so much, Kathleen, and to your colleagues and team for setting this up, and of course echoing your thanks to Karen as well, and also echoing your land acknowledgement. Thank you very, very much for doing that. So also thank you for the invitation to be in your classroom. Although virtually, it is always exciting for us to reach those who have joined us as a result of being in your class, but also those of you who have joined us online. So thank you for spending the next hour with us. We're delighted. And really, we're taking this opportunity to raise awareness around international humanitarian law and taking the opportunity of the commemoration of the 70th year anniversary of the Geneva Conventions as a marker to review what is the current status of international humanitarian law and what do we need in order to improve protection in years to come. Now, international humanitarian law, it's also referred to by some states and countries as the laws of war, also as the laws of armed conflict. International humanitarian law is the body of law that applies during times of armed conflict. So this includes both international and non-international armed conflict. And it is designed specifically for the battlefield, and it is designed in order to limit the negative effects of armed conflict. Now, IHL includes limitations on how parties to the conflict are engaged in the fighting, so how they go about conducting war. IHL also outlines the individuals and people who are protected and need to be protected by the parties to the conflict. For example, if we look at the title of the 4 Geneva Conventions, we see various groups of individuals who are protected by the conventions themselves and by IHL writ large. And that includes the wounded and sick, the shipwrecked, prisoners of war, those who are detained, as well as civilians. And so what we have seen is that the Geneva Conventions in this particular celebration of the 70th anniversary is really within a long line and tradition of attempts that have been made to limit the negative impact of armed conflict. And this is both a long-standing tradition, as well as a global tradition. Now, we have records that date back hundreds and thousands of years in some circumstances, which tell us that attempts have been made to regulate armed conflict, as well as attempts in order to limit the destruction associated with conflict. And so we know that the Geneva Conventions are a modern manifestation of this practice and attempt by governments, by states, by parties to the conflict, by civil society, in order to limit that destruction associated with it. And so, for example, on the top right-hand part of your screen, it's an image taken from a report that came out of the ICRC Somalia delegation. A group of researchers and historians put together the report that identified there was a code and practice in Somalia that identified particular categories of people who needed protection during times of armed conflict. And so they identified, for example, peace delegates, people who are associated with religion, guests, the sick. We had identified children and the elderly. And so we have this as one example of the long-standing tradition of this codification of armed conflict. The codification of the laws of armed conflict. Now, in addition to the slide, the photograph there on the slide, we also have other previous examples. So looking at as well, of course, what is referred to as the Lieber Code or Lieber instructions. It was drafted by a professor and then adopted by the President of the United States in order to speak to what were the rules associated with the fighting at the time for the American Civil War. In addition, also up in the screen, we have what is referred to as the Martens Clause, named after the Russian delegate who presented it at the drafting conference, which was again an attempt to codify the laws of armed conflict in order to ensure that the parties to the conflict understood what their obligations were. So we see that there have been these long-standing attempts and an ongoing attempt in order to codify and provide instruction to the parties to the conflict as to what their obligations are during times of armed conflict. Now what you have on the screen is a little bit of a historical mélange, if you will, of what some of the developments have been under international humanitarian law. So we see, of course, in the top left hand of your screen, an individual helping a soldier. We know that coming out of the Second World War, we had that particular focus, an ongoing focus on the wounded and sick and also shipwrecked. We have during the 60s and 70s, 50s, 60s, and 70s, an increase in the number of non-international armed conflicts, so conflicts that were taking place within a sovereign territory. And a lot of the debates and discussions associated with the application of IHL to those particular types of conflicts. Of course, we had the adoption of the additional protocols and additional protocol 2, which provided further clarity around the IHL that applies during times of a non-international armed conflict. But here we have a bit of a screen capture there of the attempts by which to increase respect for international humanitarian law, even in times of non-international armed conflict. The third photograph there on the top of your screen is some of the, if you will say, less glamorous or less known elements of means by which to comply with international humanitarian law. And this is an example of troops who are demining an area in Yemen. Again, we're looking at the ongoing impact of the use of explosive weapons and that ongoing impact on the civilian population. And then we have a current initiative that the ICRC has undertaken. It is a website that captures stories of compliance with IHL. The research is done with several universities from around the world, and this is an attempt to tell the story. We know that there's a lot of examples of IHL not being followed, and I'll address that later on in the presentation. But this is a means by which to engage in some of the debate and the discussion about instances of when IHL is complied with and why is it complied with, and what can we do to create more of those circumstances in which IHL is indeed followed. So I'm going to move on to a little bit of a history lesson, if you will. So exactly, we're celebrating and we're commemorating the Geneva Conventions, but what are the Geneva Conventions? So they were adopted in 1949. They were a culmination of years of work from 1864 up until 1949. And it's a culmination of work by both states as well as the International Committee of the Red Cross, or the ICRC. There's an expert during the discussions in order to capture in modern treaty format what laws govern international humanitarian law, and in particular for the Geneva Conventions, the laws that apply in international armed conflict. So the first convention was written in 1864. Of course, you all know we have the Battle of Solferino and the outcome of that great event, and the founding of the Red Cross and Red Crescent movement. And from 1863 and then 1864 with the convention and the additional conventions that followed in the early 1900s, then 1929 for the third convention, and then with the drafting during a couple of months in 1949, the Geneva Conventions as we know them today. And so these conventions entered into force in 1950. Throughout the decades that followed, we had increasing number of ratification. And then there are now 194 states that have signed on to the Geneva Conventions, and they are deemed to be universally applicable. And so we have, 194 states parties, signatories of the Geneva Conventions, which makes them one of the few pieces of international law that are indeed universally signed and applicable. Now, as I had mentioned earlier, the conventions identify certain groups of people who are afforded protection under international humanitarian law, and it's governments who came together and who worked on the agreement. And since then, the Geneva Conventions have formed the bulk of modern international humanitarian law in its treaty format. Now, building on the Geneva Conventions, you'll see on the other side of the slide on your screen right now is the additional protocols. Now, as I had mentioned earlier, we saw an increase in armed conflicts that were taking place within states during the 50s, 60s, and 70s. And there was a lot of debate and discussion that there needed to be a clarity around the conduct of hostilities. So again, how were parties to the conflict fighting? And also a lot of debate and discussion about the application of international humanitarian law to conflicts that were taking place within states. Now, we have in the Geneva Conventions, Common Article 3, which identifies that it applies to conflicts not of an international nature. But then we also have an additional Protocol 2, adopted there in the late 70s. It has further clarity and clarification, codification of international humanitarian law that applies during a non-international armed conflict. So you'll see in the late 70s, additional Protocol 1, which provided further clarity and the law on international armed conflict. And then we also had additional Protocol 2 that provided further clarity and again, treaty law on what would apply during times of non-international armed conflict. And so these two sets of documents and the consultation with states was a culmination of government interest in this ongoing practice of codification of the laws of war. And we have these two major developments that took place, which identified, again, how wars are being fought, as well as the individuals who need to be protected. Now, moving on, we have here, and what I'm going to cover with you are essentially 6 basic rules of international humanitarian law. And when we look back to where we can find these, we're looking at some of the major treaties, as I had just mentioned, the conventions and the additional protocols. In some circumstances, we, of course, are also going to be looking at customary law and looking at the practice and law within individual countries themselves. And so I'm going to use examples throughout the next little while, unpacking these basic rules of IHL from, in some circumstances, the database I had mentioned earlier. So the IHL in Action database that the ICRC has put together in order to speak about and provide an opportunity to discuss instances in which IHL is actually followed and complied with. And now, not all of the examples I'm using, but some of them are from there. And for those who are interested in studying more in this area of law, I really encourage you to check out that website. It's a very interesting place for research and also for then being able to dive deeper into some of those situations. Now, I am using examples of instances where there has been compliance with the law or where the law has developed in order to make sure that it's addressing a particular humanitarian issue. But I want to say that by no means am I using these examples to minimize any violations that may have occurred in the exact same conflict. And so we have examples from an operational perspective of instances where we have compliance, but also non-compliance with IHL. And again, I'll come back to that at a later point. So the first rule we're going to be talking about is distinction. So the principle of distinction is that direct attacks can only be launched against a legal target. We have it again in Additional Protocol 1, where we can find some of the legal text on this, that civilian objects shall not be the object of direct attacks, and that attacks have to be strictly limited to military objectives. Now, an example of when the principle of distinction has been developed and has been attempted to be abided by is the development of the ban on the use of anti-personnel landmines. So it was identified during research that anti-personnel landmines were an indiscriminate weapon. They couldn't tell the difference between what was a military objective and what was not a legal target, so for example, a civilian. And there was also a lot of data that was coming back saying that the overwhelming victims of anti-personnel landmines were in fact civilians. And so there was a large-scale movement in order to ban anti-personnel landmines. And we have, of course, the culmination of that is the treaty, sometimes referred to as the Ottawa Treaty. And a specific example of a party to the conflict who has attempted to follow this is we have example from 2002 from the Philippines and the Moro Islamic Liberation Front agreeing to no longer use anti-personnel landmines, and also recognizing that they then had an obligation to give a directive to their members so that way they knew also not to use them. So again, we're using an example of when the principle of distinction is abided by, and when we have this practice that reinforces this very, very crucial principle within international humanitarian law. Now, the second principle, and it's important too, I want to point out that that these principles should not be exercised in isolation. Rather, they need to be looked at, and the assessment needs to be done all together. So proportionality, we also find in Additional Protocol 1, we're looking at Article 51, and it states that you have to do a balancing, if you will, or a debate and discussion between the concrete and direct military advantage that's anticipated from an attack, and that needs to be looked at in comparison to the civilian loss of life, the civilian damage, and that civilian loss of life or the civilian damage cannot be excessive in relation to the concrete and direct military advantage that is anticipated. The principle of proportionality is oftentimes where you hear the discussion of collateral damage. Collateral damage isn't a technical term for under international humanitarian law. Instead, we use this principle of proportionality. And so as you can hear from that description, using the text from Additional Protocol 1, that there are instances in which if the loss of civilian life and if the damage to civilian infrastructure is not excessive, then that indeed could be a lawful attack. Again, so long as it meets the other principles of distinction, precautions, etc. And it's also where we get this idea that, again, you're going to hear a lot of that in the discussion in media about whether or not, if there was collateral damage, whether or not that collateral damage was excessive, and if, in fact, the attack itself was disproportionate. Now, as you can imagine, I'm sure you're all already thinking, how states and how parties to the conflict do this assessment is incredibly difficult. As an intellectual exercise, even in and of itself, it's incredibly hard. And so just imagine in real life, in operations, operators, legal advisors, commanders, senior officers providing instruction on how to make sure that they are doing that assessment in conformity with the law. And an example of an attempt by which to provide instruction on this, I'm taking this from the IHL in Action website, so you can find this information there. It's NATO's ISAF tactical directive on the use of force. And we have it from, of course, General McChrystal, who was the commander at that time. And I'm going to read out to you a part of this instruction. So he says, I expect leaders at all levels to scrutinize and limit the use of force, like close air support, against residential compounds and other locations likely to produce civilian casualties in accordance with this guidance. Commanders must weigh the gain of using close air support against the cost of civilian casualties, which in the long run make mission success more difficult and turn the Afghan people against us. I cannot prescribe the appropriate use of force for every condition that a complex battlefield will produce. So I expect our force to internalize and operate in accordance with my intent. Following this intent requires a cultural shift within our forces and a complete understanding at every level down to the most junior soldiers. I expect leaders to ensure this is clearly communicated and continually reinforced. The use of air-to-ground munitions and indirect fire against residential compounds is authorized only under very limited and prescribed conditions. And so this is from several years ago, from 2009. But again, it's an example of a means by which you had a senior, obviously the most senior officer, there providing instruction to his officers and his staff in order to provide instruction as to how they should go about implementing this rule of proportionality. So moving on to our third principle, and that of precautions. Now, again, we can find the legal text for this in Additional Protocol 1, and it outlines the expectations of what precautions need to be taken. And it says that constant care shall be taken in order to spare civilian population, civilians, and civilian objects. Now, oftentimes in the midst of operations, you'll find that operators actually implement the rules of precaution as one of their first steps. So they're taking steps at a very early stage in order to ensure the principle of distinction is being followed. They're ensuring that the principle of precaution is being followed. And examples of that is making sure that munitions that are being chosen for a particular attack are not going to result in excessive civilian damage and loss of life. An additional place where we can find an example of where the principle of precaution has been captured, we can turn to, again, I'm using the US as a lot of examples, the US Naval Handbook from 2007. And it states that the laws of targeting therefore requires that all reasonable precautions must be taken to ensure that only military objectives are targeted, so that non-combatants, civilians, and civilian objects are spared as much as possible from the ravages of war. So moving on to our fourth basic rule, we have the prohibition on the use of sexual violence. So we have explicit references to the use of sexual violence in the Geneva Conventions, particularly in Geneva Convention 4, and the prohibition on the use of rape against women. This was then also developed in the additional protocols, in particular additional protocol 2. And then we have, since then, an ongoing recognition of the severity and the scope of the use of sexual violence in armed conflict. And with that ongoing use, and some have argued growth of the use of sexual violence during times of armed conflict, the correlation of the need to further stigmatize it in order to prevent it and in order to increase accountability for those who actually do use sexual violence in times of armed conflict. And so we see this ongoing development, and I'm going to turn to international criminal law now in order to follow some of the developments that have happened since the 70s in the additional protocols. So we have, there was a recognition in the statute for the ICTR, the tribunal dealing with the genocide in Rwanda, that recognized rape as a war crime, and the court had jurisdiction in order to be able to try those cases. Then building on that, there was case law in ICTY, ICTR, and then we had then we had the development and recognition in the drafting of the Rome Statute for the International Criminal Court, an ongoing enunciation of sexual violence crimes. And it was recognized in the Rome Statute that these violations were not just prohibitions against women, but against everyone. So the fact that they are a war crime when they're committed against men, women, boys, and girls. And so I'm moving on now to our fifth principle, and that of the protection of impartial humanitarian action. So both the Geneva Conventions as well as the additional protocols recognize the special protection that need to be afforded to both the delivery and the provision of humanitarian assistance, impartial humanitarian assistance, as well as the protection of the individuals who are actually providing that service. So we have an ongoing recognition of this legal obligation. One recent manifestation of this, of both the protection of medical assistance as well as the protection of those who are providing that assistance, can be found, for those who are following this issue, you'll of course know this, but UN Security Council Resolution 2286 passed in May 2016, which reminded states of their obligations to not target hospitals in the provision of medical assistance, and then also to ensure that that medical assistance could in fact be given. Now, the ICRC, along with MSF, along with numerous national societies and other actors within the global medical and humanitarian community, have continued to try and raise awareness of the ongoing practice in some places of attacks against the medical mission, so against medical staff, as well as the buildings or the vehicles where medical assistance is being delivered from. They're raising awareness through different social media campaigns or large research projects. So the ICRC had a large research project called Healthcare in Danger, again, gathering data and also sharing best practices as to how everyone, parties to the conflict, government, civil society, can all contribute towards increasing protection of the medical mission. In addition, of course, you also had the very popular social media campaign of Not a Target, and reminding parties to the conflict that, in fact, medical workers, regardless of what side they're providing assistance to, are indeed not a target under international humanitarian law. Now, an important nuance of this rule is that you have, of course, as I mentioned earlier, that prohibition on directly attacking places where medical assistance is being given, the direct attack on humanitarian assistance. But then there's also obligations on the parties to the conflict to allow for humanitarian assistance to be able to make its way through to those who are in need of it if they themselves cannot provide that assistance. One of the interesting areas of this is looking at, as you all know, there's a lot of rhetoric and dialogue and discussion around terrorism, that being a political designation. And you'll know, for those, again, who are following this with interest, there was a UN Security Council resolution just passed a couple of weeks ago. It's 2462. I always get that number mixed up, which urges states that even when they are undertaking measures to address terrorism, that they must assess how those measures impact the provision of humanitarian assistance. Now, there's a lot of debate and discussion around this particular topic. We need bright minds in order to help work our way through this. And so for those who are interested in doing further research and writing in this area, I very much encourage you to do so. As we know, international humanitarian law applies to situations of armed conflict regardless of the reason for the armed conflict or regardless of the legality of the armed conflict. And so what we have to remember is that international humanitarian law, of course, the Geneva Conventions, additional protocol, other treaty law that has been written and drafted since then, making sure that that law applies regardless of the reason for the fighting. So if it is deemed, in fact, a situation of violence associated with terrorism, if it has reached the particular threshold of an armed conflict and it meets the criteria of organization of the armed groups, then in actual fact, we know that IHL applies and that the provision of that impartial humanitarian assistance needs to be protected. And the protection of impartial humanitarian assistance is really one of the manifestations of international humanitarian law, not taking sides between the various parties to the conflict, but instead identifying there are certain individuals and certain people who need to be protected. They need to, the negative effects of the armed conflict need to be limited on those particular groups. So for example, civilians, those who are wounded and sick, no longer engaged in the fighting, they need to be protected, and that assistance needs to get through to them. And so finally, basic rule of IHL, really looking at the protection that's afforded to those who are deprived of their liberty. So we know, of course, international humanitarian law prohibits arbitrary detention and deprivation of liberty. We also know that international humanitarian law guarantees that those who are detained or interned, whatever the situation is, of their deprivation of liberty, they have the fundamental guarantees, so whether that be the judicial guarantees or administrative procedures, to ensure that there's an understanding of why they're there, how long they can be there for, if they're charged in a criminal context, what the charges are, making sure that their fair trial rights are guaranteed. In addition, we also know that they need to be treated humanely. There are no circumstances in which it's acceptable or in order to engage in the practice of torture or cruel and inhumane treatment. And those are absolute prohibitions on the use of torture and cruel and inhumane treatment, even in situations of armed conflict. So we know we can find clarity again in the Geneva Conventions, but in Common Article 3 in particular for non-international armed conflict. And we know that we can find it elsewhere within the conventions and additional Protocol 1, identifying what are the entitlements to those who are deprived of their liberty, whether they're prisoners of war, so combatants who are detained in an international armed conflict, or for example, civilians who are interned. And so we, of course, and I just used a couple of examples there throughout the 6 basic rules to identify situations in which we had the practice of compliance with international humanitarian law. But of course, we know that all we need to do, I'm sure everybody's actually already read the news or seen the news today, where we have examples of allegations of violations of IHL or actual findings and evidence of violations of IHL. And so we know that there are many instances in which IHL is not followed. And this was actually contemplated by the drafters of the Geneva Conventions. And what you would turn to if we're first looking at the Geneva Conventions for what do we do in a situation of a violation of IHL, we turn to what is commonly referred to as the grave breaches regime within Geneva Conventions 1 through 4. And so what the expectation is, an obligation on the high contracting parties, is that they have an obligation to ensure that they have implemented legislation necessary to provide effective penal sanctions for serious violations of IHL. In addition, so serious violations of IHL include willful killing, torture, inhumane treatment, unlawful deportation. But in addition to those effective penal sanctions, high contracting parties have the obligation to stop the breach. They have obligations to prevent further breaches. They have obligations to search for individuals who are associated with the breach and to also launch an inquiry. So then, developing on the grave breaches regime, we of course then have international criminal law. And so we know that we have both international criminal law as well as domestic criminal law, places where we can go to with allegations of war crimes. And so we have this ongoing development between international criminal law, which is essentially the means by which it states that if you commit this serious violation of IHL, it can amount to a war crime. And we know, for example, from the Rome Statute, the definition of what are possible war crimes found within the Rome Statute. And based on that, we then know that international criminal law, the primary organ we're dealing with right now, of course, is the International Criminal Court, and their jurisdiction in tandem with, of course, national jurisdictions, in order to be able to deal with violations of IHL and violations of IHL which reach the level and threshold of a war crime, of a crime against humanity, or elements of the act of genocide. And so we know that, and there's, of course, for those who are interested in this interaction between international criminal law and international humanitarian law, of course, you will see some of the language from the Rome Statute, for example, looking very similar to text from the additional protocols of the Geneva Conventions, and you'll see that this is where those two bodies of law exchange and continue to speak to each other. And so we know, though, that international criminal law really kicks in after the allegation and the committing of a particular crime. And so what I would like us to think about today as well, though, is the attempts by which to prevent those crimes from taking place in the first place. And so what you'll see up on the screen, working backwards, are examples of staff from the International Committee of the Red Cross doing outreach to armed forces from around the world, training them on international humanitarian law. Because we know that international criminal law or domestic criminal law, national criminal law, can act as a deterrent for some to ensure that they don't commit particular crimes. But what we also want to look at is not just the role of criminal law, but what else do we need to do in order to ensure that soldiers, fighters, that they want to follow IHL, that they're choosing to follow IHL, that they understand what IHL expects of them. And so there are attempts to be made to do trainings with both non-state actors as well as government forces around the world in order to ensure that they understand what the law is, that they have access to training, they have implementation of IHL into their policy and doctrine and practice. And in order for them to also understand how can they ensure that their soldiers, that the members of their armed groups are indeed following IHL. And so there's actually a really interesting study by the ICRC called Roots of Restraint. Again, the finding is available online. So if you Google Roots of Restraint ICRC, you'll find that publication. It's published in several languages. And this was a study that did an assessment of both non-state actors and armed groups, as well as government armed forces, looking at why do they comply with international humanitarian law in particular circumstances. You'll find that there are several major findings there, which connect to and highlight the obligations on those of us who train. So this includes both governments as well as others who participate in training, for example, the ICRC or Canadian Red Cross. It's part of my job to engage in training with the Canadian Armed Forces on a very regular basis. And so the findings within the study are better to inform our own practice and how can we improve the training and access to international humanitarian law in order to increase compliance with IHL. Now, another example of means of prevention is a practice, for example, the Canadian Armed Forces. They have a code of conduct. It's summarized in 11 rules, which is a profound, very good distillation of the basics of international humanitarian law, much like we've just covered today. But I thought you would be interested to know, for example, that it does identify that they have to make sure that everyone is treated humanely. Also, obligations about reporting breaches of the laws of armed conflict. And so this is an obligation on members that they have to then follow in order to ensure that they are indeed complying with IHL. And so in closing, it's these potential examples I hope you have found interesting that continue to guide us and inform us and remind us that there are many situations in which international humanitarian law continues to protect people on a daily basis. And we turn to the Geneva Conventions as that modern basis, that basis of modern IHL in order to remind us of the expectations of protection, to remind us of the minimums during times of armed conflict, and the profound responsibility and need for IHL to be respected and to be implemented. And for those who are fighting to know and understand the rules. But it's also the knowledge that international humanitarian law is not followed and is in actual fact breached, both intentionally and unintentionally on a daily basis. And it's as a result of that profound death and destruction associated with those breaches that we also continue to do this work on raising awareness and attempts to increase compliance with international humanitarian law. So Kathleen, if I can hand the floor back over to you.
Great, thank you so much, Catherine. We do have a little bit of time for questions if you're open to questions.
Yeah, of course, that's no problem.
Okay, great. I'll look here. Does anyone want to raise a question or a comment? Yes, I'm just going to get you to talk in the microphone just so people can hear, if that's okay. Nope.
Maybe this is just a comment.
Sure.
I've seen that the Red Cross, they go out and they kind of educate rebels, people who are fighting. My understanding, the rebels in the jungle, they don't follow any rules. How do you expect them to follow international humanitarian laws?
And would you like me to answer that right away, or will we take a couple of questions? I'm happy to do either.
How about you go ahead and answer that one?
Sure. I actually think that there are lots of instances, you're correct, that non-state actors don't follow the rules. But there are also a lot of instances in which they do. And I think you'll find that I think there's a lot of common misperceptions as regards to compliance with IHL, that it's particular groups who do follow it and particular groups who don't. And I think what's important when we're unpacking why do people follow the rules, both for non-state actors as well as government actors, trying to understand the reasons for them following it. And I would actually encourage you to take a look at the IHL in Action website, and you'll see that there's a lot of examples of non-state actors engaging with compliance with IHL. So the non-state actors, so we don't refer to them as rebels because then you're assigning essentially a political designation to them. But you'll actually find, so ICRC does outreach with non-state actors, there's also an organization called Geneva that works specifically with non-state actors, and it deals with them on particular issues, and it gets them to sign on to what is called a deed of commitment. And this is a positive statement by the non-state actor that they will comply with particular elements of international humanitarian law. And again, this can work in favor of the non-state actor for various reasons, all of which we wouldn't have time to go into today. But I really encourage you, for those who are interested in taking a look at it, take a look at Geneva Call's website, see what the work that they're doing. It's quite incredible. And again, also taking a look at the IHL in action, and you'll see that there are a number of examples of non-state actors who have and choose to follow IHL. So I think we need to be aware of that there is sometimes a particular narrative, and that we instead need to look at, yes, there are lots of individuals who do violate IHL, and we have means by which to respond to that. But then also we need to look at what more can we do to prevent those violations, and how do we convince more people to follow IHL, both governments as well as non-state actors.
Thanks for that, Catherine. Yes, yeah. I think, Regan? Yeah. I think that is also useful in terms of kind of turning the tables and looking at the positive side of what motivates people to actually find it. I love that you raised that within your presentation. Are there other questions either in the room or on live stream? I have a couple.
Sure.
Okay. So one question that I had is just in looking at those non-state actors and looking particularly at the principles of an international humanitarian law, how do you think, or what are the areas you think that are most challenged by the rise of non-state actors within international conflicts or internal conflicts?
Okay, yeah, no, that's interesting. What do you mean the most challenging? Do you mean for them to follow, or do you mean for people to track, or what do you mean by most challenging?
I'm just in terms of how non-state actors may challenge our traditional notions of how to address international humanitarian issues.
Sure. Yeah, no, and I think that it's not just non-state actors within the realm of IHL that are challenging, if you will, the traditional norms. We have seen an increase, an explosion of non-state actors related to armed conflict over the last couple of decades, and I don't think there's a simple answer to that. I think the Roots of Restraint study is an interesting response. So realizing, okay, we have this increase in number of groups, what makes people tick? And so I think you have some of those particular responses that say, if these particular groups are forming and then disbanding and forming and disbanding, they're changing over time. What can we do with those individuals? What can we do with those groups in order to increase their compliance? Because I think I would say that at the starting point, a lot of people don't know about IHL. And so I think the starting premise is that non-state actors are just made up of people, just that, soldiers and regular armed forces are just people. And so we know that if you're going to be recruited or you're going to decide to join an armed group, knowing the rules of IHL beforehand or once you've joined the group would be really beneficial. So even opening that up as a debate and discussion. I think another really interesting point from the Roots of Restraint study is that IHL and the principles of IHL can't be divorced from kind of the local traditions and practices. So if someone's practice already aligns with the principles of IHL, we're going to see more conformity with it. So I think that's a really interesting point for us to think about going forward.
Right, thank you. I'm scanning the room. My audience is very shy today. Any online? Okay, so my next question is actually specifically for students, so it might not be as pertinent to the people online, but I'm interested as a senior legal advisor for the Canadian Red Cross. I wonder if you could share what that job entails, just in case anyone's interested in kind of moving into that field.
Oh, wow. Okay. Sure. Yeah, I'd be happy to. Well, I have an amazing team across the country. and we are responsible for, I describe it in 4 ways. So one, we do dissemination. So as I had mentioned during the presentation, somewhat tangentially, there's a responsibility on states to disseminate IHL. There's also a responsibility on national societies to disseminate IHL. So we do this work also in partner with the International Committee of the Red Cross. So my team across the country, they organize events, they raise the profile of IHL, they increase training of IHL with teachers, with universities across the country. So that's one. The second is the training that we do with the Canadian Armed Forces. So there are a large number of trainings that we participate across the country throughout the course of a year. So I also both deliver that training and advise on it. There's also our dialogue with the government on compliance with international humanitarian law. And so this forms part of our confidential dialogue with the government. So we provide our thoughts and analysis on particular issues all related with IHL. So for example, on the cluster munitions, on disarmament practices, we've engaged in discussions on the Arms Trade Treaty within the last year. So that's the fourth, and then it's also advising my colleagues here at the Canadian Red Cross. So Canadian Red Cross has an international expertise on medical work, and so I provide some direction and assistance and advice on how we engage in those operations overseas. So again, I have this a small but mighty team who execute that across the country, and we're part of a team that does policy and humanitarian diplomacy, all related with humanitarian issues.
Thank you for taking that question on, as it's kind of a left ball one.
Yeah.
Okay. Any other questions? No. Okay, we have just gone over an hour, and I just want to really thank you for taking this time to share your knowledge with us and celebrate the 70th anniversary of the Geneva Conventions. I wonder if we can give a round of applause.
Thank you. If I could ask for everyone, if you can take just 30 seconds, we really appreciate feedback. So I have it there up on the on this screen. The Slido. And so I just ask everyone to follow those instructions and complete the evaluation. So I'd really appreciate it. But thank you so much for the invitation for today.
Thank you so much. And enjoy.
Okay, thank you so much. All the best, and thank you again for the invitation.
Great. I will post your presentation in our class website. That won't be available for our folks online, but I will reiterate the evaluation form there.
Wonderful. Thanks very much. Okay. Bye, everyone. Thank you.